Hello, my friend. If you're coming to this video or to this podcast, if you're listening, I want to say, first of all, I'm sorry if your petitioner has passed away. That's difficult, not only on a human level, but absolutely adds additional feelings when you're waiting for the immigration process and it's tied to this person being alive and they've since passed away. So first of all, I want to say I'm sorry. The second is my hope is that after you listen to this, you see that there are options available for you, that there's a possibility, that there's hope, and that if you feel like we're a good fit for each other, you can reach out to me. I've been an immigration attorney for over a decade and helped lots of people go through this exact process we're going to talk about today called humanitarian reinstatement. And this is something that you can do whether you're in the US or whether you're in your home country and your petitioner has passed away while you're going through the immigration process. So if you're watching this on YouTube, I'm going to share my screen. And then if you are listening to this, then my suggestion is, you can go in and Google some of the things that I am sharing with you. You can look up USCIS humanitarian reinstatement to see kind of what I'm seeing. And the nice thing about any of these websites, any of the USCIS websites, is you're going to be able to see it in your preferred language. So I'm showing it in English. If you prefer it in another language, I totally get that. It's available for you there. So let's go into what is humanitarian reinstatement. Now, it's a really important component to know that this only applies to you. This is only going to be helpful for you if you were the principal beneficiary. So you were the person that was listed on an I-130 and it was approved. If it was still pending or you were like a spouse of someone who had initially been petitioned for and all this other, or maybe you're a child who was later born, humanitarian reinstatement is not going to be the avenue for you. What you want to see is that the I-130, and you'll see this on the receipt notice, the I-1 or the approval notice, even better, is showing that the I-130 filed by someone, and that someone has since passed away, for you. And it's going to say your name, and you'll have an approval notice. If you don't have the actual approval notice, don't worry about it. That's okay. If when you Google it and you look up the receipt notice number on the USCIS website and it says it's approved, then we know that this is applying to you, and that's a good thing. We just need to know that this has been approved. The reason I really emphasize that it has to have been approved is there are certain case types where if it was approvable when filed, specifically in the 245I context, if it was approvable when filed, then we are good to go and we can keep moving forward. That's a totally different analysis and frankly, just a different process. All roads lead to a green card, whether we're talking about 245I or humanitarian reinstatement. It's all different ways where we can try to get you to the green card. But this specific process requires an approval notice. Like it requires the actual approval of the I-130 for you, not for one of your family members. And it can't just have been filed. It has to actually have been approved. So if that works for you, then we continue to the next step. So you see on the receipt notice or the approval notice, it was filed by someone. That someone has since passed away and it was approved and it was filed for you. Awesome. Then we know we're in the possibility of humanitarian reinstatement. What happens is that person's I-130 can still be used to help you, assuming the priority date is current. This is like kind of a complicated concept. We have to look at the visa bulletin to determine if you are, if your visa category is current. Why don't we go ahead and do that? Because this is a complicated thing as it is. Let me go into March 2024. I'm going to jump in here so you can see I just Googled visa bulletin and we're going to jump into March 2024. We scroll down and you can figure out based on the family preferences, what category you're going to be in. This is especially important if you entered the country without permission. So if you entered the country without permission and let's say that this was filed it was filed by your sibling who was a U.S. citizen. You are Mexican, and your sibling filed this before October 2000. Then your priority date is current. You can also come down here and look. For a lot of these, you're allowed to go ahead and file a little bit early. So as long as it was filed before April 2001, your priority date, April 15th, 2001, your priority date is also current. So you have to kind of make sure before you pull the trigger on any of this, you have to make sure that all your ducks are in a row. But let's say that your sibling passes away and you're realizing, wow, these dates are now current. I can file, but what happens next? And that's kind of where we're going to come in. We look at humanitarian reinstatement. The trickiest thing is you have to have an I-864 sponsor. This is where things get the most complicated. Is you have the I-130, they're going to call it good. They're basically saying that as long as you're like a good person, you show that you're deserving of this discretion. The I-130's already been approved. You finally got into your priority date. Everything's good to go. The issue is now, usually that person would have been your sponsor, but now you need a new sponsor. And what do I mean by sponsor? It just basically means that you need to have someone in the U.S. vouch for you, or I should say someone who has status in the U.S. vouch for you to say that if you fall on hard times, you're not going to become someone who depends on the U.S. government to take care of you financially or medically. Like that this person is going to help you out if you need food, housing, and that sort of thing. That's what a sponsor is saying is, I'm going to take care of this person and I have the financial means to do so. But in cases like this with humanitarian reinstatement, you have to be a very specific person in order to go through this process. For this, they have to be a U.S. citizen or a national or a lawful permanent resident. So they have to have status. They have to be at least 18 years old. And here's the really complicated part. They have to be one of these types of family members. They need to be a spouse, parent, mother-in-law, father-in-law, sibling, child. So as long as the kiddo is over the age of 18, they're still considered a child, or a son or a daughter. That means they're 21 or older, a son-in-law, a daughter-in-law, a sister-in-law, brother-in-law, grandparent, grandchild, or legal guardian. And at the end, and so the sponsor has to be one of those people, and they have to make enough money to show that based on their household size and their income, that they can sponsor you. The way that you find this out is you go to the Poverty Guidelines 2024. And you have to pick where you live, where the sponsor lives. So most cases are going to be the people who live in the 48 states who are on the mainland. And we figure out, if this is your child who's 18 years old, they don't have any kids, so they're going to have them as their household size. They don't have a spouse. They don't have anybody else they got to take care of. It's going to be two people, the child themselves and you as the immigrant. We have to show that the child makes at least $30,660. If I get my numbers out here, $30,660 per year. Okay. That's what we have to do to meet this requirement for the I-864 sponsor. Now, keep in mind, and it says it on here, that it's a matter of discretion. So it's a matter of discretion. So we want to show that the pros of granting outweigh the cons of denying it. Okay, so if you've got a lot of criminal history, multiple DUIs, we're going to have to, what I would recommend is, number one, we want to really make sure that you're not removable, that you don't have a criminal history, or you don't have something that makes it where they're actually going to figure out, oh, well, we should deport this person rather than grant them the green card. And number two, if you have these issues, let's say you've got a couple of DUIs, what I would do is to show, we have to add context. Life is not black and white facts. Life is very complicated. So we have to add context so that USCIS can understand what was going on in your life that led to these DUIs and what you have since done in order to prevent ever getting DUIs again, so that we can show that it is a favorable exercise of them granting you this option through humanitarian reinstatement. My friend, I'm going to stop here. I hope that this is helpful so you understand a little bit about what the humanitarian reinstatement process is. Again, there's the basic eligibility requirements that are listed on the USCIS website, and those are an easy thing to click through and kind of get a basic understanding of. And then if you'd like more help, please reach out to me. I'm at New Frontier Immigration Law, and whether you're in the US or whether you're out of the US, humanitarian reinstatement is an option for you. So even if you live outside the country and your petitioner has passed away after the approval was already completed and you just haven't gone through the green card process, maybe you were waiting for your visa bulletin category to become current. As you saw, that can be like 20 plus years for certain categories. I'm so sorry that your petitioner has passed away, because that's your close family member. But nevertheless, I hope that you see that there's options available for you. Let's get started.